Okay, hello everyone. My name's Kanita Williams, and welcome to today's Toolbox Talk session on how to maximize profits while experiencing changes during project performance. I am the chair of the American Bar Association Construction Law Forum's Toolbox Talk series. We come together about every 6 to 8 weeks and have a little 30-minute discussion on topics and areas that are important to litigators in the construction law field. Today we have some very experienced speakers. We have John Wolf with Peritia Partners and Jose Pienknagura with Gallagher. They have a wonderful slide presentation today on how to maximize profits while experiencing changes during project performance. I'll just give you a little bit of an intro about each of our guest speakers. John Wolf is president with Peritia Partners. He has over 35 years of experience in the development and construction industry. He has provided advisory, analysis, and testimony on complex domestic and international construction-related projects involving standard of care, constructive and directed change, work delay, termination, suspension, acceleration, disruption, and productivity issues. And we also have, Jose Pienknagura, Director of Large Construction at Gallagher, and he has more than 4 decades of risk management experience from the client side. Jose adds a unique layer of value to the Gallagher team. Prior to joining Gallagher in 2019, he served as an executive officer, general counsel, bond executive, and risk manager for a U.S. national contractor that merged with an international engineering and construction firm. Thank you guys for joining me today. I look forward to you elaborating more on how litigators and contractors alike can minimize risk and costs while encountering not delays, but changes during construction. Without further ado, thank you.
Can you just pass forward through the slides a little bit?
Yeah.
Is it switching?
Okay. Keep going.
I'm still looking at the cover slide.
Interesting. I am definitely, oh, it says your screen sharing is paused. Hold on. Okay. So can you see it now?
Now I'm looking at the very last slide, the question slide.
Yes. Okay. So let me go ahead back to presentation mode and I'll get you guys back. Give me 1 second. Okay. There we go. There we go.
There it
There we go.
goes.
There we go. You want to start here or go one more?
One more. Let's get past this.
Okay.
Okay. So, so that's fine. I'll just pick up here. You guys,
I'm going crazy. This is too much. Okay, hold on. Let me try to get you back. I'll lose too much time. Okay. We good here? Here.
There you go. Okay.
Okay.
So hi guys, I'm John Wolf. We're going to go through this pretty quick to make sure you guys have plenty of time for questions. Just putting a definition on the contract management control process, which is what we're talking about here. The contract management control process is a risk management system, and it's one of the systems that's really needed to maximize profits from a risk management point of view and handling any type of contract, whether it's federal, private, new construction, whatever. Kanita, can you go on to the next one real quick? And when you deal with contract risk management systems, there's two important parts of it. It's the timing of when senior management needs to pull in outside expertise, with outside counsel, outside consultants to help resolve disputes during the project or change order issues that are going the wrong way, and to make sure the company's profitable. The contract management system also provides a roadmap, meaning when you bring in those experts early or you bring in that outside counsel early, part of the job is to figure out the roadmap from the contract management point of view of how to resolve the issues and disputes that are ongoing during the project, because that's when you can maximize the profitability. Once you get past the project substantial completion date and you're still dealing with these things, all you're looking at is profitability dropping with trying to save whatever you can out of profitability. Keep going, Kenita, please. And so what we've done is we provided you guys all a checklist of some of the more concentrated items that you need to review as far as the contract management system. When you come in to review disputed change orders, problem projects that are ongoing during the performance period. And the checklist has to start with, especially on a problem project, reviewing the bid and the contractor's estimate. Figuring out if there were conflicts, omissions, ambiguities. Was there a clarification acceptance list attached to the bid or to the contract that helped understand what was in and outside the scope of work that the price or the contract sums about? Next one, please, Kenita. Performance, really trying to understand and recognize, were directed changes made in a timely manner, were constructive changes identified and recognized in a timely manner by your project team that you're working with. Where there change orders or payment application sign-offs and where rights were waived during the performance. And then were notice rights preserved during performance? Were there letters written? Were there reservation of rights put on change orders for certain issues? That now that issue is still disputed, but you have rights to still go after it. All those things have to be addressed in the contract management system and checked when you first get on. Go back one, please, Canada.
Yes, I'm sorry. Now I don't want to go forward.
That's
One
fine. I
second.
could talk to it. So the
Okay,
second
yeah,
part, the third part is quantifying changes, which she just great at.
right here.
Um, yeah, quantifying changes. During the project, you got to follow the contract. What are the direct costs, the markups, the food, the overhead, all that kind of stuff. But the bigger one, which is really that last one, if there's an ongoing issue, make sure that your accounting department, in coordination with the contracts management system or requirements, are opening up job cost accounts or cost accounts to track those direct costs that are specific to those discrete issues. In the old days, they used to call this 99 accounts. These days, with modern accounting systems, it could be anything. But tracking those costs to the level or degree that are potentially disputed items is important to separate them out from the base bid numbers. So there's transparency and that there's a systematic way in which that's being tracked. Number 4 is avoid constructor changes where possible. This gets into what we talked about in item number 2. Is the team able to recognize when constructor changes are being issued to them during the project? And that's because if something's being done constructively, you want to convert it to a direction. You want to challenge the owner or challenge the sub and say, hey, look, the teams are doing this constructively, but is this actually a directive or not? And formalize it into a directive. Or stop doing it constructively. And the direction then is to not prejudice the owner and say, hey, do you really want to keep doing this constructively? Or are you directing us to stop this constructive behavior and get back to the way the contract should be? So getting that kind of thing ironed out early during the project and having outside counsel and experts help with that process is important because that's something that usually a team can't do themselves. And then, managing the contract performance. The contract performance system, the risk management system of the company has to be able to expand to bring in team capacity to execute REAs and claims during the performance period. It needs to be able to retain the information if an REA or a claim is unsuccessful and you do have to get into post-construction. So if you properly retain those documents during the job and you keep 99 accounts for the costing and you have converted as much constructive change to directive change in the letter writing campaign during the project, you will then reduce the amount of monies that are needed for the dispute resolution process. And now you're also giving a better chance to improve profitability even after the job. So that's another reason why we're talking about, check that box off if you're coming in. Kanita, real quick. We're trying to speed up here.
Mhm. That was very good.
So there's a white paper that we wrote about this. I think this white paper is about 6 months to a year old. It's out there. It's available for everybody. It provides a checklist and it provides a lot more detail into all the different topics that were talked about there. And we want to open it up to any questions that people may have, which I think is the next slide. Yeah.
Okay. Um, if anyone has any questions, I'll ask that you put them in the chat. I have a few questions I wanted to ask. So without further ado, now if there is a disputed change, should it be taken up as a claim or an REA? And can you just elaborate on what an REA is in case someone doesn't know?
Sure, Jose, you want that? You want me to take it? I guess I got it. So REA stands for Request for Equitable Adjustment, and that's usually more speak you see in the federal court systems or the federal processes systems than you do in the private. Um, the decision to make a claim or to take a disputed change order and turn it into a claim or to submit it as an REA, um, as we write about in the white paper, has to go through some thought process. When you submit an REA, you're allowed to recover your preparation costs. So if you have an outside consultant or even in-house consultant, uh, and you are getting into pulling together a lot of documentation or substantiation, sometimes these REAs might have 400 pages of documentation behind them, cost reports, schedules, letters that went back and forth, and you have $10,000, $20,000 worth of effort to pull out together, and you think there's a good chance you can actually settle that, then the REA process has some advantages than a claim because you can, number one, recover some of your REA preparation costs. And then there's other issues of the REA process in terms of the way to negotiate that goes forward in the process. The
Yeah.
claim process has other uh, challenges or things that can't do, like you can't submit the preparation cost, for instance. Sorry, Jose, you were going to say something?
No, am I unmuted now?
Yeah, you're unmuted.
Oh, great. I just wanted to summarize some of what you said. Time of engagement in projects is very crucial. In my 40 years doing this, one of the biggest liabilities I ever felt in the projects is the project team not being willing to share with outside counsel or consultants or even upper management when they're getting into a little bit of the tricky situations that happen on every project. The type of engagement is also very important. You do not need to bring in your experts and your lawyers and put them in front of the owner or anybody else immediately. They're basically advisors trying to guide you through the contract. And you do need to follow the contract. One of my biggest failures in most of my jobs is my guys never following the contract, not providing the proper notices, not providing the proper advice, and not doing what they need to do in order to early on resolve the issues. If you leave them to the end of the job, as John said, you're going to be having a much more difficult time in order to resolve what you need to resolve. In addition to that, you have obligations to notify your insurance carriers. If you are carrying errors and omissions coverage, you need to notify them immediately once you find out there's a problem on the job. The reason for that is most of those policies are written under New York law that's very strict and the time of notification. If you notify them in time, you might have your attorney fees covered, you might have your advisors covered, you might have your experts covered. Then it's very, very important to understand how insurance works in when you're having a claim or a problem on a job. Go ahead, John.
No, that's where I was going, especially with the claim thing. So when you make the decision between an REA and claim, all that notice, all that trilateral relationship with the bonding company, all that comes into play because some of those REA prep costs you can submit with the REA process, which would incorporate all that stuff we just talked about. But then, weighing out how strong a case you have, whether you have to certify it or not, which gets you into False Claims Act, possibly if you're doing a federal government, then you make the possibility of going down a claim submission process, which takes you into an ASPCA kind of process, which you have to make sure the bonding company is on board for and all that kind of stuff. So there's a lot of weighing that you have to do to make those type of decisions on which path to follow, an REA versus a claim or an REA and then convert it to a claim. That if you haven't done all the preparatory work in your contract management system during the job, only becomes more difficult and limits your options. And that's why we were talking about bringing in the experts, bringing in outside counsel to help sometimes make sure when you have a problem project that the team is not having a bunch of constructive stuff or is putting notices to challenge and convert things from constructive to directive so that you can have the options of thinking through the REA or claim process or just resolve it as a change order during the job because you are starting to get caught up on your notice letters and you are starting to convert things that are constructively having to direct, you change the dynamic during a bad project, sometimes helps out.
Early advice leads to early resolution, is my experience. And the
Yeah.
problem in most construction jobs is early advice is hard to come by because the team itself is resistant. For the lawyers in the school, one of the best selling points for clients that you have is, look, if we can come in and give you advice on the contract, help you guide, be the outside source that's not involved in the project, and see what's going on and see how we can resolve it. How can we talk to the other party in order to attain resolution? That's very, very important. And my best advice for everybody on this call is talk to your client. Let them understand that the pennies they're investing now will become big dollars at the end. And if you have to go to the court of contract resolution or contract appeals in the federal government, that's a loss for everybody. Nobody comes out ahead when you're doing that. Then early resolution, early communication, attempts to settlement, bringing outside parties to be a third year in that job, somebody who's not working every single day with the other party, is very, very important. Go ahead, Kanita.
Now, you were discussing a directive versus a constructive change. What exactly is the difference?
So a directive is, a formal writing where an owner or a contractor to a sub has stated that we're going to do a change or we're going to do a certain change in means and methods or a certain administrative procedure change. It's formal, it's written, it's documented, both parties agree to it, have an opportunity to respond to it, so they're not prejudiced, that type of thing. Constructive, unfortunately, happens a lot on bad projects. Projects that go bad is where the parties, by a course of conduct, fall into a means and methods or a system of working of doing scope, either in terms of administration or actually sticks and bricks being put in the job that are different than what are on the plans and specs or called for in the administrative procedures of the contract. Handshake deals, for instance, if you're just going old school. And that leads to all types of problems later on if you try to get into post-construction scenario, i.e., kicking the can down the road, and only increases the risk of your client if things can't get resolved. So when you do understand and get involved and see that a lot of that's going on, you try to flush it out in the resolution process, back to what Jose said, as early as possible. Because large times, if you get the job, those folks that had all that constructive behavior and course of conduct may not be available. And now you're really at risk as a contractor. Those people aren't even able to testify 2-3 years down the road and just move on to different companies or move on with their lives. Jose?
It's the difference between a formalized claim and a non-formalized claim. If you do not have a formalized claim that follows the contract, your rights as a contractor are going to be diminished. I do not like CCDs. I've talked to many builders, many people in our projects, telling them that's the worst way to build a job. Formalize what you're doing. If the owner says build a wall that's 10 feet tall and 50 feet wide, then tell them we need to do it in writing. If we need to discuss the price will be resolved within 15 days. Do not do it on a handshake. Do not do it in a way that the contract does not allow you. That's very, very important. And probably the biggest thing is tell your clients, follow the contract. You negotiated the contract, follow the contract. That's the easiest way to maintain peace and progress on a job.
With these large scale jobs, it's kind of surprising, though I guess it matches human behavior, that there be all these handshake changes. How often are you guys coming across that in projects that you're pulled into? It
Uh,
might be, you might just work with great clients who already know what they're doing, but I mean, what does it really look like out there?
in the big projects, let's talk about projects like the LA Rams. You find it all the time because of human nature. The project manager and the owner's rep want to be best friends, best buddies. Therefore, they feel they can go in and do things as friends. But the reality is, there's a formalized contract that tells you how to be friendly. And when it happens, it becomes more and more difficult because once you start doing that, you do it over and over and over. By the time you catch up to it, it's too late. And maybe the lender, the owner is not really aware of what that project manager or the project owner, a project representative had been doing. Therefore, it happens all the time on every job. And part of the problem is because it's not formalized, nobody really knows about it under the two individuals or the four individuals that have been doing it. And it's very difficult to resolve. Let's say you are doing something on a handshake that's a $250,000 change or $1 million change, and that's not being consulted with the lenders. The lender can come back and say, look, you didn't consult with me. You don't have anything in writing. I don't know about this. Your problem. Then where are you going to go and resolve that issue? Then you need to train people to be friendly, but document, document, document. There's a reason why contracts have notice provisions. There's a reason why contracts have change order provisions. You need to follow them. Be friendly, be nice, go have a beer, go have a taco, go have a burger. But when it comes to the job, do it in writing, follow the contract, do what you're told to do from day one. There's a reason why people spend 4, 5, 6 months and a lot of money negotiating the document. Follow the document. And that's one of the most difficult things you'll find with builders because they all want to be friendly. They want to have this great rapport with each other, and they tend to deviate from the contract, which is one of their biggest mistakes. In big jobs, the bigger the job, the bigger the problem if you do that.
Yeah. Yeah, it's the confusion that PMs and upper level personnel, project executives on projects start commingling the sales process for the next project, even a big next project, with the quote legal obligations and duties of following the contract. And it's human nature, even on a big job, doing the US Strategic Oil Reserve right now, huge project. And we have PMs and contractors out there who are being all nicey because even though they got 4 more years to go on this job, they're already, saying, trying to bid other work on other projects that they could possibly take on the next year or two with the same other contractors and owners and subcontractors they're with. So they all want to be friendly because they're all bidding work and trying to do work on other projects. But somebody has to come in and go, hey guys, you're $30 million in the hole on this job because you have all these handshake deals going on. And the whole contract process of resolving all this stuff and change orders is being bogged down because nothing's written, it's nothing documented, but people are spending money trying to keep up with this. Next thing you know, the bonding companies won't help them on bidding those next projects that they're all trying to do because the bonding companies are looking at their financials just deteriorating because there's all these outstanding pending change monies that aren't resolved between the parties. So it becomes an issue.
Not only that, John, I used to tell my guys, if you're trying to sell the next job while you're having problems on this job, you just lost this job and then you lost the next job and the job afterwards. I
Exactly.
always told them, build the job, build it properly, and you'll get the follow-up jobs. Build the job, have a claim, and now you've lost a client and you won't have the money that and the resources to go ahead and do other things. As you said, bonding companies are very curious. When you have a claim, they tend to look at you carefully before they allow you to get the next job. Then that's very important. Do the job you're doing and do it well, follow the contract. And for the lawyers in this call, that's the biggest thing you need to tell your clients. Follow the contract, follow the notice provisions, do what you're told to do based on the way it's written. And you're going to be friendly because at the end of the day, if you have a great project like we did with the Rams, we had no claims. Everybody was happy. Everybody went in to the next stadium, the airport, the next hotel, whatever it is, because nobody had to fight. When you bring John and myself in, usually the way things are done now is you're going to have a claim, you're going to have a fight. If you bring us early and you're organized and you're following the contract, you're going to avoid not only the angst of the fight, but the expense and the time it takes. Usually when a claim happens, John will tell you, it could be 2 or 3 or 4 years down the road before resolution.
And once someone pulls you guys in, then does it look like? What has happened when you guys get consulted? Is there a notice of default? Is there just going to be a potential discussion about a change? How early on should you be pulled in?
We have projects where we're brought in within 2 or 3 months of the contract being signed sometimes. And it's not a notice of default. Sometimes it's just, a team that, bid the job per certain qualifications or certain assumptions and clarifications. And immediately on their first quote, uh, third point review or contract review period, which they do quarterly on some jobs or some jobs every 2 or 3 months, they realize that stuff is already happening on the job during the first mobilization period or initial, contract or the initial contract work that's starting up that's different than anticipated. Maybe they have limited access that they didn't expect or something. And they need to what we call clear the deck. There's already a amount of change, constructive change or change occurring, and there needs to be a reset. So that's one scenario. Another scenario is that's been going on for a year or two. And finally, one party, the owner or general contractor to a sub, or the owner to the general contractor, has had enough and they actually start flying the notice letters around or the default letters around. Then we get that call. That's already too late. At that point, we're not going to be able to maximize profit at that. At that point, we're just trying to maintain a margin as best we can and to set the client up for as best we can some recovery, maybe a third party mediation, maybe some type of facilitated settlement. But usually at that point, the damage has already been done. And then, of course, the last time we get brought in is purely post-construction, after substantial completion, and we're just in pure claims mode. But the preferred place that clients should be bringing us if they have an active working contract management system that's being used as a risk management system would be much earlier, would be, a couple months into a project typically when you're starting to do your what we call contract management auditing to check and to maintain that the companies aren't in a sales mode, but are just focusing on that work and clearing the deck and getting all changes resolved timely. Jose?
Yeah, I agree. I think the earlier you get brought in, I used to bring in consultants within a couple months before the job started, so we can be organized, understand what we need to do. And bringing a consultant doesn't mean to have him there full time. It's bringing them in for a few hours so they can see the systems, understand the relationship with the owner, understand what needs to be done. When it comes to the legal group, I think the legal group needs to come in before in order to explain the contract to the contractors, during in order to maintain and check to make sure everybody's doing the right notices, the notifications are going out, so on and so forth. And what happens, based on your question, is when do they call us? They call us when they wake up in the morning and there's 3 nasty letters coming from subcontractors and the owner saying, look, you're not doing your job and you're in default. When that happens, when they call you in, at that point in time, the process is already going to be very difficult to manage. It becomes expensive, becomes difficult. You're in a recovery mode. The other time when you were called in is when accounting starts seeing that there is deficiencies on the accounting records. In other words, the billing and the collections are not the same. The owner's retaining large amounts of money, or the subs are claiming they're not being paid at the right intervals. Then that's when you get brought in. I think bring in consultants and lawyers early, during, and if you need to for the closing, bring in for the closing too, because then when closing a project fast and efficiently is very, very productive. And a lot of projects, they go well during the time you're building, and then they get to the end, and that's where the fight starts. Then I think having those consultants, having those lawyers is very important.
I don't know if anyone else has a question. We have 1 minute left. Does anyone else have a question? I can't see my chat for some reason. If no one else has a question, I'm going to just shoot one more.
I actually do.
Okay, go
Yeah.
on.
Thank you. Hi, Don Ray. Thank you, gentlemen. This has been very helpful. When you're dealing with whether intentionally or unintentionally, owners and upstream contractors who say, okay, we'll present your PCO, we'll get it signed, but you need to start the work. We got to maintain the schedule. And you get this a lot. And the work starts and the change order sits, or halfway through the work, it's not signed, and then you get disputes about anything and everything to cut the change order amount. How do you deal with that? Because once you've started the work, you're in for a penny and in for a pound.
Correct. That's the CCD process. Go ahead, Jose.
No,
Yeah.
I was just gonna say, first, I put limits on CCDs. In our jobs, there was a maximum amount of CCDs we'll do without resolution. In other words, let's say it's $1 million. You hit $1 million, you stop accepting CCDs. Number two, my change orders are valid for 2 weeks. If they're not resolved within 2 weeks, there's a repricing.
Yep.
That's the way you deal with it. You do not let them sit. I was talking to John, and we've been working on what we called a dispute resolution that happens every 2 months, where every CCD, every change order gets resolved on the job with both the owner and the contractors. You need to create a system by which you're not working blind. Part of the problem with CCDs is the power shifts when you're doing that. In other words, once you started the work and once you started paying for it, the other party has all the power to say no and basically put you in a place where you're not going to like the result. Then my suggestion is be disciplined, resolve them every month, put a cap on CCDs.
Correct.
Great, thank you.
It's making sure the other part of that is, that's the forward pricing part of it, where, CCD is supposed to be forward price, supposed to agree. And, we agree that we have to have that debt clearing session that we used to even put in our contracts, that, there'd be a once a month or twice a month or a quarterly review of all changes and settle it out. But if you have a contractor that does do CCD work, say it's underneath the $1 million threshold that you set for the job or for your company. If they do start it, they need to set up that 99 account, what I called in the accounting system. They need to track the actual discrete cost and the invoicing, and that includes their general conditions time, their superintendent time, the PM time, overseeing that changed work. Because there's no guarantee that you're not going to wind up 60, 70% done with that work, or even 100% done with that work, and not get that change order signed or resolved, even if you're doing the clear the deck sessions, and even if you have a limitation. So if you don't have all that discrete tracking going on, then what happens is you get done with the work, all the leverage shifts to them. And the way the leverage shifts to them is they sit there and go, insufficient information. Give me more backup to the change order request. You get that game. So if
done that, got the T-shirt.
Exactly.
And by the way, Donald, one of the things you need to be very careful with CCDs and large jobs and smaller jobs is pay-ups. Pay-ups contain waivers.
Yeah.
The waivers are not limited to
Correct.
what you're seeing. The waivers are very broad waivers. If you do not watch the waiver provision on your pay-up, you might be waiving those CCD claims, period. Then be very careful with your clients. And by the way, I see that right now more than I've ever seen it before. Owners are really good at putting a certification that this is all you're owed and there's nothing outstanding. Do not sign that pay up, because if you do, you might be waiving your rights.
Correct. Some of our clients that we're advising, we've been doing this now for about a year and a half because of this issue. We're submitting the pay applications with an exclusion list. Just like you do a bid where you have your inclusions, exclusions lists, and we'll put a copy of the change order, the pending change order log, and say, hey, this pay application is valid for this submission for this money, and attached is here's our list of outstanding issues that are not being waived or not, because you're getting into that issue. The other thing you got to take a look at is, depending what state you're in, some states like Texas, especially on state jobs, they now have limitations where a contractor can stop the work if the CCD amounts start getting over a certain dollar amount or a percentage of the base contract. That in Texas, for instance, there's 2 other states I know that have the same rules now that just recently got passed in some state legislators. If a contractor gets to 5% of his base contract and outstanding change work, he can stop performing the contract. So these continuing performance clauses that, like in the federal arena, and some states are now being challenged by the various contractor associations and are getting traction in the legislature and are becoming part of the legislative law. So there's some states where there's a lot of public contracts or even private contractors are out there that have continuing performance clauses that are actually null and void or in violation of state legislature. And many contractors and subcontractors don't know that. So that's another way, if you're in one of the states, that can help on the CCD issue and the scenario you're talking about. That largely goes unnoticed by a lot of people if they don't check their state rules.
Well, we have run out of time. Thank you so much, John and Jose. If that's it, I think we've got to go. We've got to close out.
Thank
But
you,
I'll be in touch,
Commissioner.
you guys. Okay.
Sure.
Thank you all.
Bye, guys. Thank you. Bye, guys.
Bye-bye.